Okay, so here's an interesting case. Danielle N. Marion versus the Commonwealth of Kentucky, case number 2013-CA-001-481-MR. So Michael Caperton is going to reverse and remand for further proceedings, so essentially a retrial. Now, he had said that 2 reversible errors had happened. The witness on the witness stand had kept on standing up and moving back and standing up and moving back, and the judge, to sort of console the witness, who was the main victim, the judge said, "You did a fine job and you answered the questions truthfully, I'm sure." So there's a little, wiggle room with that "I'm sure" thing, so that actually puts a little doubt. Now, after the judge had said, "I'm sure you did a fine job, I'm sure you answered the questions truthfully, I'm sure," they said an admonition that I wasn't saying that he was guilty or not guilty, or that he was innocent. I wasn't taking a side on this case, and so they admonished the jury. So essentially the jury will disregard that last remark. And a lot of times an admonishment is good enough, but if it seems clear that the judge thought that Norris was the victim and he was 100% innocent, then that's not a fair trial. And that was one of the reasons why this case was actually overturned. So if the judge appears to decide, which side that they like, then that's something that could be appealed. They had also said that the court erred in allowing the defense counsel to impeach Barbara Parrish about a former theft charge. So this is about Danielle N. Marion, but her and Barbara Parrish were the ones that went around, walking around, trying to rob people and trying to get a ride into town. So they were just wandering around and trying to find some money and finding a ride. So they were basically, co-conspirators to this thing. But Barbara Parrish is going to testify against Danielle N. Marion in order to get 2 sentences off of her 18-year sentence. She only had to do 20% of the sentence before probation was allowed, so she went to jail for 3.6 years. She went to jail for 3.6 years for attacking Norris, hitting him in the head with a rock, and then hitting him with a hammer. And Norris is going to live through this attack. But, so Danielle and Barbara, they are together in this thing, and I'll tell you a little bit more about what they did. So when it comes to the reversible errors, because they didn't impeach Barbara, I think that just means they didn't get to cross-examine her, or they didn't get to mention a former theft charge. I wonder about this case, because if you speak about, prior charges of a person, that does prejudice a jury, but then it might also be information that's pertinent to the whole thing. So they're sitting there saying because, Barbara Parrish was their main witness, and she had already been convicted, and she was trying to get a lesser sentence. Barbara Parrish also was the main instigator, and so because they had used her testimony in order to convict Danielle N. Marion, essentially she wasn't a very credible witness to begin with, and so they couldn't impeach her for a former theft charge. So that one, I've heard both sides, both for Michael Caperton. He says that you can't mention former charges in a trial, a criminal proceeding, because it'll prejudice the jury or the bench judge, the bench trial. So the court, the first one I understand, but I think they stretched it. And then there are 2 other appealable charges that were not reversible, and one I question it. So when the judge said you did a fine job to Norris, the victim, and you answered the questions truthfully, I'm sure, that's what overturned the case and said that, a complete new retrial was to happen. Now, there's 2 other objections that the appeals court, that the lawyer for Danielle N. Marion had made. One was that a court didn't dismiss juror number 78 during voir dire, the jury selection process. This juror, and then the other one was a guilty verdict set aside because it was unreasonable verdict by the jury, which is a harder case to make. It's interesting that they made that case, but essentially appeals court can't, retrial. So I understand that one. The one I don't understand is this juror number 78. So juror number 78 said several times that it was the defense's job to prove the innocence of the accused. And he didn't believe in innocent until proven guilty, but that you're guilty until proven innocent. And when they asked him about it, he says, yep, that's my opinion. Yep, if someone accuses you, then I just assume that they're right no matter what. And he said it 2 or 3 times. He said it under, cross, and then they mentioned it as they were walking back to the room. So he's, this juror number 78 said 3 times that he believes that the defense needs to prove that the accused is innocent, which is the opposite of the philosophy of American court system. That's major. That's huge. He's not being fair. He's not being impartial, and he's sitting there saying he's okay with not being fair and impartial. He's going to hurry up and get this conviction. Yep, she's guilty. Why? Because she was accused. That's all he needed to know. So that, to me, seems like a reversible error that Michael Caperton had erred on. And then the other one about the impeaching Barbara Parrish. So let me tell you the whole case, okay, everything that had happened. Now, Danielle in Marion is going to get convicted of 3 charges: of second-degree assault, first-degree burglary, first-degree robbery. I don't know. I guess she stole something. I didn't read that part where they stole something, but they had attacked him. And burglary and robbery and that kind of same thing. So she got 5 years for the first charge, 10 years for the second, 10 years for the third, to be served concurrently for a total of 10 years in prison. So she's going to get 10 years in prison, and Barbara Parrish is going to get 18 years. So Barbara Parrish is, the main culprit. Now, Danielle, she appealed the court and said that they had a reversible error during the jury selection, and they didn't declare a mistrial, and they didn't allow the impeachment of a witness, and the jury verdict was clearly unreasonable. So I mentioned all that before. So here's what happened. Danielle Marion and Barbara Parrish, they're in Cumberland County. They're walking along Leslie Road. They're looking for money and a ride into town. Danielle and Barbara run into Freddie Carey. But Carey said he wasn't going to give them any money, and he wasn't going to give them a ride into town. So they run into one guy. He says no both times and somehow was able to get away unscathed. Then Danielle and Barbara Parrish go to Highland Norris's property. He was an octogenarian, I don't know, some scientific thing, doctor or some shit. So Highland Norris is in his barn, and Danielle and Barbara walk up to him. And they say, give us money, give us a ride. Highland Norris said no. And then that's when they walked outside. They talked about it, and then they said they were going to assault him and rob him. And they used a rock and a hammer. And so there's some question about if there was 1 rock or 2 rocks. It seems like Barbara Parrish had actually used both rocks, or that Barbara Parrish was the one that threw that used 1 rock, because only 1 rock was found on the scene. And so Barbara Parrish could have just been straight up lying about Danielle Marion. I mean, she was there, and, clearly Barbara Parrish was the lead instigator. What did Danielle Marion actually do? I think that is a question of fact. But that's when the attack happens, and then that's it. Then the cops are called. This Highland Norris is pissed off. He asked to get a gun from a cop, and the cop said no. The cop arrested 2 ladies, and then they were charged. And that's it. That's the whole, the whole crime. Now, Danielle Marion had appealed, on the things that I had said. So here's the explanation for why juror number 78 was not dismissed. So this seems crazy to decline to reverse on this ground, okay? So a juror clearly says that the person is guilty and they need to be proved. How can you prove someone's innocence? How do you do that? How do you do that? Someone accused of something and say you have to prove your innocence. So maybe an alibi? I mean, what? So they said that, let's see, they quoted the Kentucky Rules of Criminal Procedure, RCR 9.361, says where there's reasonable ground to believe that a prospective juror cannot render a fair and impartial verdict on the evidence, that juror shall be excused as not qualified. So clearly they couldn't render a fair and impartial verdict. He already thought that, the accused was guilty. So Michael Caperton in the appeals court reviews this objection, via the abuse of discretion that's provided in Ratliff v. Commonwealth, Kentucky 2006. So the case Ratliff v. Commonwealth, their, abuse of discretion, that defines what the abuse of discretion is. If a juror can't render a fair and impartial verdict, it is the probability of bias or prejudice that is determinative in ruling on a challenge for cause. Pennington v. Commonwealth, Kentucky, KY 1958. The court must weigh the probability of bias or prejudice based on the entirety of the juror's responses and demeanor. There is no magic question that can rehabilitate a juror's impartiality is not a technical question but a state of mind. Shea v. Commonwealth, KY 2007. Supreme Court of Kentucky has ruled that if after expressing an opinion about an aspect of the case, the juror claims to be able to render a fair and impartial verdict based solely on the evidence, a trial court does not necessarily abuse its discretion by allowing that juror to remain on the case. Allen v. Commonwealth, KY 2008. So if the judge, after the juror says, you're guilty until you're proven innocent, and the judge says, okay, that's wrong, you're innocent until proven guilty now, even though you have this ridiculous opinion, can you render a fair and impartial verdict based solely on the evidence? And they say yes to that, then that opens up the door for allowing that juror who is clearly biased to sit in on the case. So I believe Michael Caperton was incorrect on that one. He did, reverse and remand the whole case. But still, the two reasons, one of them was right, and then the two reasons he didn't, one of those were wrong. So Norris walked off the stand. Okay, so during the trial, you have Highland Norris who's walking off the stand. Defense counsel's giving him hell. He just can't take it. And he walks off once, walks off twice. The judge issues a recess, but said that if you do it again, a mistrial is going to happen, and that he could have just asked the court for a recess instead. So none of this actually matters when it comes to whether or not it could be, reversed. The only thing that matters was at the very end of, Highland Norris getting up and storming out and walking out into the hallway, and then after he was warned a second time, he did it again. So to assuage Highland Norris that he did, he did okay. The judge said, Norris, you did a fine job and you answered the questions truthfully, I'm sure. So when she said, or Norris or the judge or whoever the judge is, when the judge said, I'm sure, that puts doubt into whether or not, the questions were answered truthfully. So I don't think that's clearly siding with one person or another, but because, this person's seriously insulting the court with their outburst and just storming off the stand. You're allowed to do that. Highland Norris had some balls to, storm off the stand. Now, an admonition was given afterwards, so disregard the last remark, and the judge explained that the judge was only consoling an upset witness and wasn't choosing sides. I think that's a good explanation. I think that's a fine and dandy explanation. It wasn't that big. It was just some offhand comment. So just some sort of offhand comment where it looks like you're being partial and biased can get a case overturned. So I feel like that was, Michael Caperton reversed and remanded on this issue. And here's the legalese that they use. So the Supreme Court in Matthews v. Commonwealth, KY 2005, it said this: a trial court only declares a mistrial if a harmful event is of such magnitude that a litigant would be denied a fair and impartial trial and the prejudicial effect could be removed in no other way. State differently, the court must find a manifest, urgent, or real necessity for a mistrial. The trial court has broad discretion in determining when such a necessity exists because the trial judge is best situated intelligently to make such a decision. The trial court's decision to deny a motion for a mistrial should not be disturbed absent an abuse of discretion. So even though a motion for a mistrial was made, it's saying that they have broad discretion. And so, yeah, I made this offhand mark. I admonished it. I think that was okay. I don't see that being such a huge thing that you would reverse it and overturn it. what does seem like they're making a decision is that this, Highland Norris is making all these outbursts, and the judge is saying it's okay. So there is no contempt of court or, hey, you need to behave. I mean, they kind of lightly sort of warned him, but that was their star witness, and they were trying to get a guilty verdict. And so I think by his behavior, and then on top of it saying, I'm sure you did okay job, I think both of those combined, maybe the judge in this outfit was being biased. So in Sharon v. Commonwealth, KY 2004, and Johnson v. Commonwealth, KY 2003, it says that appellate courts presume that juries will follow the admonition of a trial court, and that the admonition will cure an error in the testimony. So the jury will disregard that remark. It's assumed that the jury will disregard that remark. So there are two circumstances where we do not presume that the admonition cured an evidentiary error. There are only two circumstances in which the presumptive efficacy of an admonition falters. One, when there is an overwhelming probability that the jury will be unable to follow the court's admonition, and there is a strong likelihood that the effect of the inadmissible evidence would be devastating to the defendant. And two, when the question was asked without a factual basis and was inflammatory or highly prejudicial. So they can't ask a question that is just inflammatory, that has no factual basis at all. And they also, if the jury can't, put it out of their mind that the judge had said that, they did a good job, if they just cannot, just get that out of their minds. There was from Chisholm v. Lampatch, Kentucky 1961, KY 1961, the court case Chisholm v. Lampatch, Lampach. There's two interesting things they mentioned. They said that the judge must give the atmosphere of impartiality. So the court has to be fair. There has to be an atmosphere of impartiality. And then the other interesting remark was that jurors have a high regard. Notice is taken of the high regard which jurors generally have of the judge, hence his remarks will have great weight and often result in improper influence. So since the judge is the king, and the king is saying, okay, you did good with your testimony, well, that makes it sound like they're on one side and not the other. That's from Northeast Lumber Company v. Harris and 10 other cases. So the appeals court, Michael Caperton, did do the right decision, reversed and remanded it on issue 3, right, on the two issues, because Barbara was high on drugs and she was used to testify against Marion. She had a previous charge of theft. She wasn't a good witness, and they weren't allowed to impeach her, so they weren't allowed to say this is a bad witness. And specifically, that does run into a previous statement that Michael Caperton said, where you can't use prior convictions to taint a person's character. And so that's Danielle in Marion versus the Commonwealth of Kentucky. So if the judge is biased, clearly biased, you can overturn the case in a Caperton appeals court. And if the court doesn't allow a defense counsel to impeach a clearly bad witness. So those two combined. But if a juror said that you are guilty until you're proven innocent, that doesn't reverse the case. And if the guilty verdict was set aside because it was an unreasonable verdict, so you can't retrial the court, you can't retrial the case. So you could say that the jury made the wrong decision, but, essentially that's a no.